The Special Action Committee for Education is at the Western Cape High Court today for an urgent interdict to restrain the Western Cape Education Department from cutting more than 2,400 teaching posts. Now, the department says they're operating under severe budgetary constraints, and we take you there live now to those proceedings.
The question of standing. Yes, these issues were raised in the answering affidavit because there was no indication in the founding affidavit. Well, let's put it this way: the Constitution had not been annexed to the founding affidavit, from which one was able to glean what the organisation is, who the organisation is, what it's about, and what its objectives are. And it's in that context that the allegations put up in respect of their standing had been placed in dispute in some. But this is the applicant has sought to remedy that now in the replying affidavit, which we submitted somewhat late in the day. But it doesn't seem to have cured their problem in any event. Your Ladyship raises a very important point, and that is, well, who is Mr. Terence Smith? Appears to be a one-man show. We are now told from the bar that there are 3 other members.
There's no mention of him
in the founding papers, indeed. And so, but what is equally concerning is that at page 166 of this, of the record, which is in the replying affidavit, it appears to be the last of the replying affidavit, of the Constitution. The only reference to who might be a signatory on behalf of the Constitution is in paragraph 8.3, and it says the authorized signatories should be any, as opposed to and, shall be any 2 of the chairperson, treasurer, and secretary. Well, we don't know which of the other 2, which 2 in fact authorized Mr. Smith to act on behalf of the organization. So we submit to your Ladyship that in any event there is no authority on behalf of that which is also placed in issue, that there is no authority given to Mr. Terence, not in terms of the Constitution, it would appear, to have brought these proceedings to begin with.
Request a copy of the missing annexes yesterday, but I haven't yet received a copy of the replying that. Mr. Seymour, was that filed or was it posted to case lines? We've had some glitches because my case lines was only set up this morning. Was the replying affidavit filed on case lines this morning? Or
it was, my lady.
Do you perhaps have a hard copy?
I do, my lady.
Thank you.
Thank you, my lady. So
So that page you're referring to, you say that's page 166?
Correct, my lady. And as far as I could tell, I must mention this to your Ladyship as well. The replying papers were served on the department at about 18 minutes past 8 this morning, despite the fact that the affidavit seems to have been deposed to yesterday already.
That explains why I'm a bit lost, because I don't think it has been sent through to my registrar or to Ms. Hannah.
Yes. And I'll deal with this stuff under the heading of urgency. But as I pointed out, at the foot of page 166, the last paragraph 8.3, it says the authorized signatory should be any 2 of the chairperson, treasurer, and secretary. And as I pointed out, it's not clear who authorized Mr. Smith to depose to the affidavit, or to, in fact, to institute these proceedings. And we submit to your Ladyship that is not properly authorized. Then, my lady, to deal with the issue of urgency. It's a fundamental principle of our law that your case is made out in the founding affidavit. When one looks at what the applicant has said about urgency in the founding affidavit at page 24, it tells the court that it is submitted that the matter is manifestly urgent, the applicant will not be able to obtain adequate redress in the ordinary course. The remaining paragraphs do not assist the applicant insofar as establishing urgency is concerned. Your Ladyship has asked my learned friend a very important question, and that is to explain the delay between the time that they became aware of the issues raised by the reduction in post and the time that they've launched the application. My learned friend has studiously avoided answering that question in the proper way. He's directed your Ladyship to what was said in the replying affidavit. We submit to your Ladyship that it's not good enough. This is an explanation which was called for in the founding affidavit. Your Ladyship will know the cases of the case of ILB Marco, Caterers v. Greatermans. It's a case of the decision that was handed down by a full bench in this division by Friedman J. and Fagan J. It was way back in 1981 already, in which the court said that, if I may just hand up some of these cases. These cases. In which the court has said at page 110, it's the third page under the heading Fagan J, the second paragraph under the solid line, my lady. There are degrees of urgency in an attempt to deal with this diversity. A semi-urgent role is in terms of a court notice operated in this division, this being this division itself, alongside the ordinary role. Opposed matters which are not of extreme urgency but are nevertheless too urgent to await hearing in the ordinary course on the continuous role are placed on the semi-urgent role. 2 paragraphs down, the court says the following: when an applicant believes that his matter is one of urgency, he may himself decide at times to allow affected parties to entering appearance to defend and for delivering answering affidavits. He may, without consultation without consulting the other parties, arrange a date for the hearing. And then the court sets out the time frames which were truncated in that particular matter. The paragraph at the foot of the page, applicants by doing so became obliged to persuade that the matters were of such urgency and that their non-compliance with the rules should be condoned and that the matter should be heard forthwith. Respondents had no option. They were compelled by the applicants to adhere to the time periods chosen by the applicants and to appear in court on the day selected by applicants. Then only, and I skipped the middle of the part between brackets, could respondents object to the procedure followed by the applicants. And then it goes on to say that the rules, as they were then to still now 27 and 612, required an applicant to show good cause, why time should be abridged, and why applicants could not be afforded substantial redress in the ordinary course. Now, on the facts of this case, my lady, we have submitted to your Ladyship, and unfortunately, my lady, I received the index quite late, about 8:30 this morning. I wasn't able to paginate the answering affidavit, but we deal with that in our answering affidavit at paragraphs 47 onwards, and it's page 18 of the affidavit itself.
We come out of that for you, and those are proceedings at the Western Cape High Court, where the Special Action Committee for Education is busy with that urgent interdict to restrain the Western Cape Education Department from cutting more than 2,400 teaching posts.